So welcome everybody. Good morning from wherever you are in Australia, and we are recording the session, so if you need to catch up later because you've got to dive off, we'll get the link out probably after the Easter break. But I would like to start by acknowledging the traditional custodians of the various lands on which we work today and pay respect to elders past, present and emerging, and extend my respect to the First Nations people joining us today. So a brief introduction from me. I'm Angela Franks, the partner for Frazer Jones here in Australia. Frazer Jones is a HR search and recruitment business operating across the whole spectrum of HR, and we have offices in Sydney, Melbourne and Brisbane. For anybody who's been tuning into these webinars for a while now, you'll know that Cilla's been every October time helping us with understanding what HR horrors are happening, but there's so many updates, we decided to squeeze another one in. So Cilla's going to cover some of the biggest changes we've seen in over a decade and focus on a case study with a recent case study with the Fair Work Commission. She'll also cover misconduct, disciplinary action, and the importance of training and education in the context of positive duty and the workplace health and safety laws. I've already got some questions for you, Cilla, at the end. So, but we're always delighted to partner with Cilla, and again, can't thank you enough for joining us. So I'll hand over. Please feel free to put the questions in the chat and the Q&A, and I'll do my best to keep an eye on that, and then we'll cover it all at the end. So I think Cilla's also going to make the session a little bit interactive. So the chat might get a bit busy, but I'll do my best to stay on top of it. And I'll pass over to you now, Cilla.
Thanks, Angela. And thanks everybody for joining again. If we last connected in October, it's always a fun and engaging session. So thanks to Frazer Jones and Angela and Mel as well. So as Angela mentioned, today we are once again talking about HR horrors, but it's not just HR horror stories today. There'll be some good news for both, I think, employers and employees on account of the new laws. There have been lots of changes. You would have had to have been living under a rock not to have known that last year in December, the government changed laws, the Secure Jobs Better Pay legislation, and that tranche of legislation produced a lot of changes. There's not enough time to talk about all of them today, and in fact I'm really just going to take you on a quick whistle-stop tour of the changes that I'm talking to clients about most, which relates to pay transparency, enterprise bargaining, fixed-term contracts, and gender equality generally in the workplace. So there's heaps of changes. This really just is a select few items that I'll be talking about briefly today. And then after I've gone through those IR changes, I will be talking to you about a little bit of a juicy case study based on this recent decision of the Fair Work Commission. And look, historically, these sessions have been primarily for an audience of HR business partners. I understand they've got some lawyers on the call today, so I might go into a little bit more detail on some legal aspects than past sessions. So don't hold that against me, hold it against my legal brethren that are online, but I'll try to make it relevant, I hope, for everybody. So in terms of the topics, what's going on here? There we go. In terms of an overview, as I mentioned, I'm going to be talking about pay secrecy, flexible work, fixed term contracts, bargaining. Then we'll have the case study and some question time as well. So first up is pay secrecy. I think this is probably the most topical and expansive change that really affects all employers. So the pay secrecy clauses mean that pay secrecy clauses in contracts will be prohibited. So this change really affects all employers, and we're already seeing that it's actually bringing about changes in how employees are approaching matters of remuneration, which have historically been subject to confidentiality clauses in most people's contracts. So the laws were changed because the government found, and off the back of the Respect at Work report by Kate Jenkins several years ago, they found that these pay secrecy clauses were contributing to the gender pay gap. So that's the public policy reason for this change. And essentially, the changes mean that employees and future employees have the right to share or not share information about their pay, but also their employment terms that could be needed to work out what their pay is. So things like hours of work and the like. So it gives employees a right to ask each other about that information. Employees can't be forced to give the information. And importantly, these rights of being able to talk about your remuneration freely and ask each other about remuneration can be exercised after the employment ends as well. So essentially, the government has made this a workplace right. So those people who are either employment lawyers or HR professionals will know about the general protections or adverse action jurisdiction in the Fair Work Commission. These changes enshrine these pay secrecy provisions as a workplace right. And so essentially what we're saying is this new right. We can expect that employees will be asking their employers for details about other people's remuneration, for example. And the cynical old employment lawyer in me is expecting that this will also be used very cleverly as a lever for poor performing employees or people that are being conduct managed. Because if somebody asks a question about their remuneration, that will mean that they have exercised a workplace right. If they are then conduct managed or performance managed, after that, they can then say that one is connected to the other. So I've said to my clients, don't be surprised if you're performance managing an employee, if they say to you as the boss, what's your remuneration? Apropos nothing. They will have then exercised a workplace right. If you then go on to performance manage them, as you intended to do in this discussion, they can say that any adverse consequence was because they exercised this workplace right that's now enshrined in laws. So obviously a very strong public policy reason why we have these changes, but we do expect it'll probably be manipulated to bring more adverse action or general protections claims. Now, in terms of the timing of these laws, they have really staggered it to give businesses some time to get across these changes. So there's different timeframes that operate. So for contracts that existed before the 7th of December, confidentiality clauses in those contracts will continue to have effect until they're either varied or terminated. So it's not having a retrospective effect in that sense. But then contracts that are entered after the 7th of June, either new contracts or varied contracts that include pay secrecy clauses, will have the effect that those clauses are void. So from 7 June onwards, if you have a contract that has it in there, it will be void. Importantly, after the 7th of June, it will also be a contravention of the Fair Work Act to include pay secrecy provisions in your contracts. So what does that mean for all of you? You need to be looking at your contracts, reviewing existing ones and any variations that you're making to contracts to ensure that pay secrecy clauses are removed, and ensuring that you're going to have proactive, by June, compliance with these laws. So I think it is intended to ratchet up so that those past contracts that were entered into before December last year are still in play. But going forward, we can't have these clauses in our contracts anymore. Now, importantly, when we think about a contract, it's not just an employment contract. A deed of release, for example, is a contract as well. And quite often that might have information about someone's remuneration in there, and it will almost always have a confidentiality clause. So you'll need to be thinking about your deeds of release. Do you need to have a carve out so that a normal confidentiality clause in a deed won't inadvertently trigger a breach of these laws after June? And importantly, documents like STI or LTI incentive documents as well can potentially fall within this scope if there is a contractual entitlement offered. So in terms of the work that we're doing with clients in this space, we're looking at contracts, we're looking at incentive offer documentation, retention contracts as well. Anything that really has anything about rem in it from 7 June, you need to be quite transparent about that. So really, I think from an HRBP perspective, things have got a little bit more challenging. We all know that some of our leaders have favourites. Those favourites might get a little bit more in the REM bucket come pay rise time. The onus is really on you to challenge those questions, because increasingly the business is going to need to defend the decisions it's making about this. And we do expect that employees will be quite openly talking to each other about what their remuneration is, and essentially we can't stop that from occurring. So that's pay secrecy. The other big change is the changes to flexible work requests. And most of us are aware that there's been the ability to make a flexible work request since the Fair Work Act. But these new changes to flexible work requests come into play on the 6th of June. And basically it expands the reasons that someone can make a flexible work request, but importantly, it gives these provisions some teeth. Now, on the slide, and Angela will share the slides with everybody afterwards, so don't feel like you need to absorb it all now. But on the slide, we see the process of how somebody makes a flexible work request presently. And then we've got the additional factors. So essentially, now you have 21 days to respond if somebody makes a flexible work request. You need to respond in writing. And usually after that, you either say yes or no, and then it just goes off into the ether. There's nothing really that the employee can do. In the new world post 6 June, there's a requirement, if you're not accepting the request, to meet with the employee and to set out alternate arrangements that might be made if you're saying no to that flexible work request. But most importantly, if that request is refused, there is an ability to go to the Fair Work Commission to deal with that dispute. So as I said, these provisions had no teeth before. There was nowhere a disgruntled employee could go if they felt that their flexible work request was being unreasonably refused. Now they can go to the Fair Work Commission. Now, the new laws also talk about the grounds for refusal, which are just in that little box in the middle there. So it's still fine to refuse a flexible work request, but you really need to turn your mind to the legitimate basis for that. Because if you say no, you might end up in the Fair Work Commission. But if you say no, you also need to think about, well, if no, what else can we be doing in terms of those alternates? I think, the main outtake for this is that employers need to now really seriously think about these requests. I mentioned that there is an additional reason for an employee to make a request, and that's in relation to where a person, an employee or a family member is experiencing domestic violence. And as many of you will be aware, we've had domestic violence leave introduced into the National Employment Standards. So that's just supporting that change in law. So really, flexible work requests, and especially post-pandemic where many, many more people are working flexibly, we think is going to be a real growth area in terms of claims that are in the Fair Work Commission, because for the first time, post-June employees will have the ability, if they're not happy with what their employer has said, to go to the Fair Work Commission. Now, the Fair Work Commission will do its usual thing, have a conciliation, try to get the parties to agree and come up with a positive outcome. However, if that can't be conciliated, the Commission actually does have arbitration powers to make a determination. So the impost really is on businesses to turn their mind to this and to try and get a situation where the Fair Work Commission isn't essentially determining how your employee is going to be operating within your business. So I think for you, either lawyers or HR professionals, you need to be thinking about your flexible work arrangements, how you presently respond to these requests. Is it on an ad hoc basis? Do the managers just do this without any HR support? Ensure that your policies refer to the new criteria that's in that box in the middle, and really ensure that there is a proper process and a paper trail to support any decisions that the business is making around this, because, as I said, otherwise you'll be in the Commission very quickly, and the context is that the Commission will essentially be assuming that these flexible work requests can be managed, and the bigger the organisation, the greater your ability to manage those requests. Obviously, it's a bit more challenging for smaller organisations where they might have limited staff, limited funding to create something that might suit the employee. So a really big change, I think, that companies will be facing. So another big change is the prohibition on perpetual fixed term contracts. So as all of us are aware, many companies like to get around FTE and headcount by having these fixed term contracts. And many of us have been in organisations where there might be rolling fixed term contracts. So really, we're calling someone a fixed term contractor, but really there's still an expectation of ongoing employment. Now, these laws are geared towards really getting security of employment for these people who are on these fixed term contracts. And it does so by limiting the use of fixed term contracts to 2 consecutive contracts or a maximum duration of 2 years. So 1 renewal, 2 successive contracts, or 2 years. So it's a big change. You can't have a 5-year contract. You can't have rolling contracts where one rolls into the next, there's just one rollover ability essentially. Now, when I talk about fixed term contracts, I'm talking about both true fixed term contracts that don't have an ability to terminate and what we call outer limit or max term contracts, where it's got a term, but it's also got an ability to terminate the contract within the term. So almost every organisation that I work with in Australia and offshore have fixed term contracts. I think the onus now is to really stress test, why are we putting this person on a fixed term contract? Is there an ongoing expectation of work? If so, we should probably bring this person on as an ongoing permanent employee. Now, importantly, there is an ability again to go to the Fair Work Commission if there is a dispute about a fixed term contract. So it's really trying to give these fixed term employees a little bit more power in the negotiation. Now, there are some exceptions which I've included on this slide. If it is a government funded role, for example, if it's to meet peak demand or a temporary absence, for example, a parental leave role and the like. So there are some exceptions, but and also where a modern award permits the fixed term contract to be in place. So exceptions apply, but in the main, these aren't really going to apply to most Australian employers who routinely get people on fixed term contracts, essentially just to give themselves the option of terminating that employment without actually having a risk of unfair dismissal or the consequences that might normally flow if you brought someone's contract to an end. So in terms of the things that you need to be thinking about, I've just put them on the slide really as a reference point for you later, but you need to be thinking about the composition of your workforce. Do you have a lot of people on fixed term contracts? As I said, it's 2 years or 2 successive contracts. So think about it. You could have somebody on 2 3-month contracts and then you're done. If that person then has another contract, they will be deemed to be an ongoing employee. So have a think about your workforce, really start auditing the circumstances when these people and contracts are used, considering whether any of those exceptions on that previous slide apply. And then there's also a requirement to give fixed term contract employees a fixed term contract information statement. So all of you would be familiar with the Fair Work information statements. There is now a fixed term contract information statement, and that's really putting people on notice about the nature of their employment and that the rights that they have to essentially convert to a permanent position if their contract rolls on beyond the end of that the contract date. So as I said, the Commission has an ability to hear disputes about this. Many of my clients are looking at this very carefully and essentially putting people that have been on fixed term contracts for some time onto permanent roles, which probably is something that should have been done before this legislation. So it's a good housekeeping exercise, but one to really be mindful of in terms of engagement of new fixed term employees. So I mentioned enterprise bargaining. This is probably the biggest change in the legislation. I could literally talk to you for over 2 hours about this. So I've included, I won't do that, but there's a lot of content here. I've deliberately put a lot of content in the slides so that you have it as a reference point, because I'm aware that not everybody that's listening today is interested in enterprise bargaining, and enterprise bargaining may not be relevant to your workforce. So what I'm going to do is just take you on a really, really quick summary of these changes. But I do encourage you, when Angela sends out the deck, to have a read, because I really am going to go through this relatively quickly so that I can get through those high level points. Because as many of you know, the Labor government and the union movement have been complaining about the decline of enterprise agreements. And enterprise agreements are these collective instruments that outline the terms and conditions of employment for employers, rather than an individual contract of employment. And they've really been on the decline. And usually bargaining is the main relevance point for a union in any employer scenario. So it's something that Labor has wanted for some time, and these changes really will bring about an uprising and an increase in the number of enterprise agreements that are made. We're already seeing people starting to bargain for reasons that I'll explain shortly. So look, the main changes are there's an increased ability for bargaining representatives, be them employees or unions, to initiate bargaining. There are these new multi-employer streams where you can have agreements that cover more than one employer. There's this roping in concept where companies can be roped in to an enterprise agreement. There's easier pathways for workplace determinations. There's greater dispute rights so that the Fair Work Commission can deal with what's described as intractable disputes, which I'll explain shortly. They've made the agreement process much simpler, which is really good news for employers. And they've also changed the Better Off Overall test, which is the assessment that the Commission makes in approving enterprise agreements. So look, whilst it's a little bit scary, I think, for employers, the concept that they might get roped into an agreement with another company, there's a lot of wins in there in terms of the actual process for those organisations that are routinely bargaining. So definitely some wins for companies, but we do expect that we will see a lot more enterprise agreements being made in the next several years. So single enterprise bargaining is essentially the normal bargaining that we see, where one company is bargaining, and essentially a bargaining rep, an employee or a union can just now give a written request if they want to start bargaining. If there is an existing agreement in place, 5 years have expired, it'll cover the same employees. And so this is just essentially making it easier, and these laws are already in place. They've been in place since the 7th of December. Easier for employees and unions to commence bargaining. So essentially this change to the single interest bargaining process makes it easier and improves accessibility for single enterprise agreements by essentially reducing the barriers that presently exist to commence bargaining. They've also introduced these multi-employer streams, and you'll recall from the media there was a lot of discussion about multi-employer agreements, and this was the real fear factor in terms of when the Labor government put its policy positions out ahead of the federal election. And there was quite a lot of hysteria about what this means for organisations. So there are 3 types of multi-employer agreements. The first is supported bargaining. And this is really a minor amendment to the current low bargaining stream that focuses on minority employees. So it's probably not likely to be relevant to most of you. It really targets industries that have barriers to prevent access to enterprise bargaining. So this might be due to a lack of necessary skills or resources or bargaining power. So supported bargaining is there to help those lower paid industries, not-for-profits, for example, people with disabilities, First Nations people. So that's one stream where you can get multiple employers having the one agreement. The second stream is single interest bargaining, and that is probably the one that's most relevant to the people that are on the call, where essentially you can get a union or employee asserting that there is a common interest amongst different employers, and that for that reason, subject to some requirements that I'll take you through in a moment, we should be bargaining for one agreement for multiple employers. So that's a really significant change, to think that rather than having my own Cilla Robinson enterprise agreement for my Cilla Robinson employees, I now might be having them with, Angela's employees as well, and other groups. So single interest bargaining is where we expect the focus to be. But there's also this cooperative workplaces stream of bargaining, which is a new addition, which is a voluntary bargaining stream aimed at small businesses. So historically, enterprise agreements have really existed for big employers that have big workforces, and small employers have just had individual contracts of employment. So this is essentially making a cheap and easy way for them for small employers to also have enterprise agreements in place as well. And there's a benefit for cooperative workplaces, those small employers, because protected industrial action isn't available in that stream. So essentially it's saying, don't worry, small businesses, have an enterprise agreement. Your employees won't be able to go on strike during that process. So it is really quite a sort of an incentivizing reason to get those small employers that historically just haven't even considered whether an enterprise agreement would be appropriate to them. So as I said, single interest bargaining is the one that's most relevant to most of you. And on this slide, I won't go through it in any detail, but it just steps out the steps that are involved in starting this single enterprise agreement process. And essentially what this means is that you, as a single enterprise, can be compelled by the Fair Work Commission to bargain if an employee or a union write to you to say that they want to bargain. And essentially you've got more than 20 employees, small businesses and the building and construction industry are excluded from this. And so there is a carve out where if an employer has already agreed in writing with the union to bargain for an agreement, and or bargaining is occurring, then they cannot be compelled into a single interest agreement with another organisation. So what we are seeing is companies that have historically had no desire to have an enterprise agreement getting one, because if they have one already, they won't be compelled to bargain with another company. And so we're already seeing Labor seeing the fruits of its labour in an increase in enterprise agreements, because people and organisations are taking this proactive defensive step to get an EA in place to prevent being roped in to having to have an agreement with another organisation where they're perceived to have a common interest. Now, what is a common interest? Essentially, the amendments have removed historical limitations on what a common interest is. And now there is a presumption that is, if an application is made and the company has more than 50 employees, the onus is on the company to prove that they don't have a common interest with the other company that the union's suggesting that they negotiate with. So that reverse onus, again, makes it very challenging for companies. And so essentially, an employer who's been included in this single interest authorisation, if they believe that they don't share a common interest with another employer, they have to prove it rather than the union and the employee having to prove it. So the Commission will have regard to the geography where the company is, the regulatory regime, the nature of the business, terms and conditions, etc. But you can assume that if your business is, pretty similar to another business across the road, and you've got more than 50 employees, that this process might just occur without your ability to stop it. The Commission will have regard to the public interest, if it's against the public interest, for such an agreement to be made. But that's a pretty high threshold to make. So really, really significant change. I think when I talk to my industrial relations colleagues, we reflect on whether we will actually see a whole lot of common interest, these single interest employee agreements being made, or whether we'll just see more standard EAs being made as that preventative measure. Either way, the government is getting what it wants, which is many more enterprise agreements in place in Australia. As I mentioned before, we now have this ability to rope in a company into a single interest employer agreement. So an organisation or a couple of organisations could have created an enterprise agreement, and you, as a third party that had nothing to do with that, might be roped in by application. Now, we used to have this concept of roping in for awards before the modern awards came into play, where you used to have named companies. For those old people like me on the call might remember. So this is a really significant change, because it means that you might just get added to an enterprise agreement without having had any involvement in its negotiation. So I'm not going to go into that in any detail, other than to say that you really may not have any choice. Again, you can argue that it's against the public interest, but that's a pretty high threshold. And so, again, many organisations taking this defensive step of getting their own enterprise agreement in place so that they won't be exposed to being roped into another enterprise agreement that they've had nothing to do with. So this slide's probably the most relevant for those who are actually engaged in enterprise bargaining, and that is the extended powers of the Fair Work Commission to deal with bargaining disputes. Now, the Commission has always had powers to deal with bargaining disputes under Section 240 of the Fair Work Act, but it gives them more powers, and it gives them more arbitration powers, which is really significant. So the first box talks about the initial step that needs to have occurred if you are going to make an application under the intractable bargaining declarations provision. So you need to have made an application under Section 240, which is really just the normal enterprise bargaining disputes procedure. Interestingly, I'm involved in bargaining presently for a few companies, and off the back of nothing in particular, a couple of 240 applications have been made. So it's pretty obvious that unions are quite sensibly making their 240 applications so that they've ticked that box, so that there's a threat essentially of an intractable dispute bargaining process if things don't go swimmingly in bargaining. So you've made a 240 application, and there's been a dispute in the Commission already. The second requirement is that 9 months has passed since the commencement of bargaining, or after the nominal expiry date of the previous enterprise agreement, whichever is the latest. So there is a requirement that at least 9 months have passed. You're not going to get an intractable bargaining dispute, in the first month of bargaining. Commission's got to be satisfied that there's no reasonable prospect of an agreement being reached. So that's, of course, for the parties to demonstrate. And then in the fourth step is then the Commission needs to be satisfied that it's reasonable in the circumstances to make an order under these provisions, having regard to the views of the parties. So what this means is that you're going to have bargaining disputes where there is an arbitrated outcome. And so what that means is that the Commission will be deciding matters that will be in your enterprise agreement. Now, presently, the Commission could only arbitrate these matters by agreement. So the company would have to agree to put the powers in the hands of the Commission to actually work out what the agreement will say. So a really significant change. It's if you're bargaining in good faith and doing things appropriately, you won't be at risk of this. And so depending on how you look at it, I think it can be seen as a positive for organisations that are in entrenched bargaining, in very polarised bargaining positions where you just can't break through. The Commission is there to assist. But what it does mean is that the Commission might also decide the terms of your employment agreement. So essentially, where the parties can't agree, the Commission can actually determine that outcome. So it's a big change in terms of that power, where you're giving arbitration powers to the Commission about non-agreed matters. So hopefully it should mean that bargaining efficiency and efficacy will be enhanced, because people won't want to roll the dice on whether the Commission is going to give a favourable outcome. But it is a really significant threat that is there that I expect will be used by unions and employees if employers aren't doing the right thing. But similarly, if you've just got very entrenched bargaining positions, sometimes the assistance of the Commission can provide that breakthrough. So that's the legislative intention of these changes to the bargaining dispute provisions. Now, the approval process has also changed, and I think this is really great news for everybody who's involved in bargaining. The government has sought to just simplify the process to make it less challenging, to make it less prone to technical defects, which have historically meant that agreements have been unable to be approved because of technical defects in process that really didn't impact on the content of the agreement significantly. So they have removed the requirement to issue a NER, a Notice of Employee Representational Rights. That's historically been how an employer starts bargaining. And there's very prescribed content about what goes in a NER, and it was a document that used to trip up many organisations. So the NER has gone. The access period has also gone. So presently, if you are negotiating for agreement, you need to give employees 7 days to consider that agreement before the agreement is put to a vote. That period has gone. And so really the purpose of these changes is to try and make bargaining more efficient, to remove these pre-approval processes, so that making an enterprise agreement is just going to be easier for all involved. Of course, there are still requirements that the Commission has regard to when it's approving an enterprise agreement. So the Commission needs to be satisfied that there is genuine agreement between the parties, and there is a statement of principles about genuine agreement, which the Commission has on its website. So it still has to be satisfied that the parties have reached this agreement genuinely and the employees support it. There's obviously still got to be a vote. But just these procedural steps of the issue of the NER and the access period has gone. So it is significant. It means that things can proceed more swiftly. There's not these sort of rigid timeframes between, 21 days have to pass and, before you can put it to a vote. So this is all, I think, helpful for both unions and employees as well as employers, are just making it more straightforward. So good news, I think, for everybody who has historically been quite concerned about getting these timelines right. Sorry, I didn't add in those little bits. So the bottom of the slide just talks to what I've been talking about in terms of there needs to be written agreement. You still do need to explain the enterprise agreement to employees, but you just don't need to have this 7-day access period. And of course, the agreement does need to be in terms that are sufficiently represented so that they can be understood by the employees. So the other big change is the BOOT, which is the Better Off Overall test, which is the assessment that the Commission makes when it's approving enterprise agreements. So big change to the BOOT. The BOOT has been universally panned by both sides of the ledger in terms of it being complex, in terms of it being hard. So these changes really are geared towards making the assessment much more meaningful, I think. So instead of doing a line-by-line assessment, comparing the new enterprise agreement with the underpinning modern award, the Commission is allowed now to do a global assessment, which makes a lot more sense. And so I think that's really, really helpful, because most companies will make an enterprise agreement because the underpinning modern award doesn't work for them for some reason. And there will be parts of a modern award that you don't want. And that's probably the reason why you have an enterprise agreement. So having this rigid item by item assessment will necessarily mean that there's some things that are different. And if the Commission historically hasn't been satisfied that they're better off, then the agreement was at risk of not being approved. So now we move away from that line by line assessment to a more global assessment. There's also helpfully a requirement that in the BOOT analysis, the Commission only has to have regard to reasonably foreseeable patterns of work. So it reduces the ability for unions that might be opposing the approval, for example, to say, but what if somebody worked this span of hours and did overtime at this time, and come up with a very imaginative way where the employee might be worse off compared to the BOOT. And it might be a scenario which the employer can say, well, no one is ever in my business going to work that pattern of hours or do OT on the weekend or whatever it might be. So it removes the ability to point to these sort of far-fetched hypotheticals, which again, I think is really helpful for employers. But probably most significantly, it removes the reliance that we presently have on undertakings. At the moment, if the Fair Work Commission isn't satisfied that an agreement passes the boot, it will most often remedy that by asking the employer to give undertakings. And so what that means is that in order to understand what the agreement means, you have to look at the agreement plus these undertakings, 2 separate documents to get the totality of the EA. So not ideal for anybody. In the new world, the Commission can actually vary the agreement in that approval process to satisfy the boot. So what that means is that you might have an agreement that's ultimately approved that's a little bit different from the one that you negotiated and the one that the employees voted on, where they can essentially remove terms that are concerning or slightly rewrite terms so that any concerns about passing the boot will be assessed. So big change. Great that we're not going to have a million undertakings attached to every EA. That's welcome. A little bit scary to think that the Commission's just going to go and, do that themselves without the benefit of the employees or the employer or the unions having input into that. But ultimately it's geared towards removing ambiguity, removing unfairness. And the result is that more agreements are going to get approved without undertakings, rather than not being approved and being sent back to the beginning of bargaining. So again, of course, it's geared towards enhancing bargaining. So that was just an additional thing in terms of the holistic approach taken. Next slide just talks about the next wave of reforms. I'm not going to go into that at all, except to say that this is tranche 1. I've given you dipped the toenail into tranche 1, but there's a whole lot of workplace changes that the Labor government is going to focus on in the coming years, and I've just highlighted them on the screen. But moving to our case study, I wanted to talk about a recent case, Woods and Jetstar. Now, in this case, it was an unfair dismissal case, which had some pretty interesting facts. Here we had the applicant, Mr. Woods was a supervisor. He was a manager of a crew of about 15 to 20 employees. There was a Jetstar code of conduct, pretty standard situation. And he had a number of disagreements with one of his employees, and he reported that employee to HR, said that the employee was difficult to manage, put the employee on a performance improvement plan. And then separately sent members of the team off, and there was a whole lot of pretty adverse behaviour. Now, the employee that was in this guy's team separately sent a complaint to HR talking about the manager, Mr. Woods' toxic behaviours in the workplace. And some of those behaviours included publicly mocking other employees' errors, calling an employee an effing dumb C for making us all look like shit, expressing opinions that residents of Fairfield were responsible for spreading COVID. And he said that he knew about that because he lived there and they're all Asians and they're all like that. So some pretty offensive things that this guy did. Jetstar HR sent him a letter to say that they were launching an investigation, setting out the allegations in the normal way. And during the investigation, a number of additional allegations came to light, including more C-bombs and an allegation that in Christmas in 2020, the applicant also referred to employees as the Bali bomber. So delightful chat by all accounts. Now, question for you all. How should Jetstar have approached the secondary allegations? So he made allegations against an employee made allegations against him, and then this second lot of allegations came up. So could we in the chat get your views on what you think Jetstar should have done? Either no action, the allegations are pretty similar to the nature of what he dealt with in the first instance. So this is, the additional C-bombs and the Bali bomber stuff that came up. Do we pause the investigation and ask witness to provide separate complaint, or do we continue the investigation and raise the secondary allegations with the applicant and provide an additional opportunity to respond? So where are we landing on?
Yeah, loads and loads of C's and a few B's, I think, if I'm seeing this correctly.
Well done. And so that was not intentional, that we end up with the C's, given what this guy keeps saying, as the correct answer. So C is right, A+ for everybody online. So Jetstar also opted for C and sent another letter to him, setting out the additional allegations, and then finally giving him the findings to the allegations. But after getting the findings letters, and I'm sure the HR crew here will have this will be familiar to all of them, but after finding those, giving those allegations, he then raised a counter complaint in relation to the behaviour of this person that had made the complaint in his team. And the nature of the complaint was that he was regularly flatulent in the workplace. He'd put his legs up on the table and pull his butt cheeks apart and fart for as long as possible, rubbing and showing his erect penis on items and making racist and sexist comments. So very, very interesting case to read this one. It's about 75 pages, but if you can get past that, it's a good read. So what impact do you think that these counter allegations should have on the current investigation? So no impact, personal work-related grievance between the manager and his employee. Allegations should be investigated and dealt with separately, no impact, or additional allegations put to the applicant for failing to report this behaviour when it occurred. Where are we landing?
Yeah, so I think we're getting, ironically, a few more C's again.
Yeah.
A couple of D's.
A couple of D's?
One CD, mostly C's. There was a B, okay, and there a couple of B's and there a couple of D's now.
So a bit of a mixed bag. And look, I think that's representative, really. It's a bit of a tough one. There are some options that are available. I mean, here, the answer D is actually correct, that these allegations should have been, the additional allegations should be put to him, the applicant, Mr. Woods, for failing to report their behaviour at the time. Because essentially, he's the manager, he's got responsibility for this guy's behaviour, and he hasn't actually done anything when these things occurred. So Jetstar once again followed that procedure, instigated formal investigations for failing to report that misconduct. And 8 out of 10 of these allegations were substantiated or either wholly or partly. And off the back of all of that, Mr. Woods was ultimately dismissed. And the basis of the dismissal was that the allegations involved serious misconduct. Now, he applied to the Fair Work Commission with an unfair dismissal, saying that there wasn't a valid reason for termination, it wasn't serious misconduct, he was treated harshly, and that because of his age and the minor nature of the offences, as he saw it, it was a harsh dismissal. So what do you think in terms of whether the dismissal was harsh, unjust or unreasonable? No, it's serious misconduct. No, it was serious in nature, but he wasn't afforded procedural fairness. Yes, language was offensive, but he was singled out, treated more harshly than his colleagues. Or yes, we generally don't use this language in the workplace and the findings were too harsh.
We're getting a bit of everything, Cilla.
Okay, interesting. I think it is interesting, right? Because it does show that these things are subjective, but it also shows that we've all got different tolerance in terms of profanities at work, and the banter that might exist in a workplace. So look, a lot
of B's coming through.
Yeah. And look, the answer is B. B is correct. The Commissioner ultimately found that there wasn't any procedural unfairness. Jetstar investigated the complaints. They provided the applicant with details of the complaints of all of the allegations. And the Commissioner also remarked that using that kind of language was inexcusable and offensive regardless of the context of the workplace. And I think the fact that there was not just the C-bombs, but there was this undercurrent of racism as well with some of the comments about Bali Bomber and the COVID Fairfield Chinese comment as well around that made it more offensive than, somebody, using the F word in the office, which is seemingly an increasingly common occurrence. So I just wanted to bring that case up because it was a really interesting one in terms of just sort of the different steps that the business took in managing that process and the usual allegations and counter allegations that we quite often see. So I think from your perspective, main takeouts are the importance of having a code of conduct, following your code of conduct and policies, educating your supervisors about the role that they have to counsel employees and to report conduct to HR, because if they don't, then they might be in this position where it might be used against them. Again, the importance of training on policies relating to conduct so everybody has the same expectations of respectful workplace behaviours. And really just trying to foster, and I'm probably completely speaking to, preaching to the converted, but the importance of fostering an inclusive workplace environment so that everybody knows what the expectations of your business are. And similarly, the importance of adapting to new standards of acceptable workplace behaviour as society changes and social mores and expectations also change, where something that may have been acceptable 20 years ago is no longer acceptable anymore. So I said it was going to be a whistle-stop tour. Questions? You've only got 6 minutes, Angela.
Cilla, I've had my serious face on because there's a lot. So,
oh my goodness.
All right, let me try. I was trying to sort of also group them together, but it's going to be a little bit tricky. Thank you, Debbie. She says, awesome presentation, always from Cilla. All right, so I'm going to go back to the very start. There was a lot of questions around the pay. So to clarify, a subordinate can ask their manager their remuneration, and they are meant to disclose this information, or did I hear that incorrectly?
They don't have to disclose. They just have a right to ask. You have a right to not tell them. That example was given because in a situation where the manager is performance managing the employee, them asking that question would enliven that workplace right. So then any step that the manager takes thereafter, putting them on a PIP, giving them a warning, whatever that conversation was going to be about, could be positioned strategically as adverse action that was taken as a result of the person exercising the workplace right to ask about their REM. So no, you have the right to ask, but you also have the right not to tell. But it's essentially making it lawful to ask about someone's remuneration, but also to disclose your own remuneration.
And there was a question around past contracts. I think you were saying, so they're saying is, what do we do with past contracts? Is it only applicable to new contracts?
Yeah, so it's an offence from June. Contracts that are presently in place though aren't unlawful, but the relevant provisions of confidentiality will essentially be void anyway. So best practice approach is to roll out new contracts that don't have those provisions in it, because you don't want to be falling foul of the provisions post-June, where if somebody actually looks at their old contract and thinks that they can't talk about it, you'll essentially have a breach, even though it doesn't have that retrospective effect. So the best practice approach is to roll out new contracts that don't have those provisions in them, and doing that at remuneration, pay rise time, or if someone's got a variation. So where they're going to be signing up to a new contract is best practice.
Okay. And then actually another question, I don't know if you've covered it, so sorry if it's duplication, but what happens if an employee asks the employer about everybody else's pay? So the question is, does the employer have a right to decline the request to disclose the remuneration details?
That's right. And so the company isn't expected to give away everybody's personal information and their remuneration. So, but the expectation is that employees will ask each other. Yeah. And there'll be more transparency as a result. So I'm a junior lawyer. I've been at this firm for 2 years. I'm going to ask the person in the next door office what's they're on and work out where I fit. And so it's really ensuring that companies will have more rigour around pay bands and be looking at things from a gender lens. Do we have a gender pay gap? And so no, it's not requiring the company to give the information out, but it's mandating that the company can't expect that employees will keep that information confidential in the way that most organisations have historically done.
Just quickly on the gender pay gap, not in this list, personal question that came up on another webinar, was with the gender pay gap reporting when the 100 employees, is that local or global employees?
As local Australian
just
entity
local. Yeah. Okay. Fab. Thank
You've
you.
got one person here and hundreds offshore, you're not captured. So it's 100 employees based in Australia.
Based here. Okay. Fab.
You're talking about the Gender Equality Act.
Yeah.
You used to report to Wajuna, and now you need to report to employees and shareholders on that as well. If you've got 100 staff. Yeah.
Okay. So I know that was slightly separate. So there was another question. Sorry, I'm in the chat. I'm in the Q&A. There was also in the chat about, does it include KPI bonus schemes? Or so do you have to disclose, is it just salary, or is it including bonuses and other?
It's remuneration and factors that link to remuneration. So a bonus, if it's a contractual bonus, then it would be captured. So that's why I mentioned STI, short-term incentives, which can be bonuses, or then long-term incentives. So if it's a contractual right, noting that many are discretionary, so it's not, then it will be captured. So the best practice is to have your documentation, but to say that any matters that relate to your remuneration are not subject to confidentiality that might otherwise apply to the rest of the document. So I've been looking at a lot of incentive and bonus documents lately, because if it's a contract, doesn't need to be an employment contract, then it will apply. So if it's discretionary, you don't have a contractual entitlement to it, so it'll fall out. So there's a little bit of wiggle room there. But again, when you're working with your leaders about giving bonuses out, you can expect that people will probably be talking about that as well. And if you seek to stop it, you'll end up in the Fair Work Commission dealing with the general protections or adverse action claim.
Okay, great. Sorry, I've just got to quickly, they bounce around. I'm trying to stay on this topic. There was one about the mentioned salary disclosure conversations could lead to manipulation. Any advice on how to avoid this?
Oh, look, the manipulation is already occurring. So I think that there's no way to avoid that manipulation. I think people will talk to each other. People won't necessarily tell each other the truth, which is the most challenging part of it. I think from an HR perspective, an employment law perspective, just assuming that there's going to be a whole lot of transparency that we haven't previously had. That will mean that there's a whole lot of disputes, employee complaints. The most important thing is that every remuneration decision that is made can be justified. So your role in HR, stress testing, you got 3 people in your team, they've all got, excellent in their performance review. Why is Johnny getting $5,000 more than Sally, or the other way around? Just stress testing that, and provided there's good answers to that, if there are high performers, low performers, then it doesn't create an exposure for you, but it just creates an uncomfortable situation where people will be aware of it. And sometimes some companies are saying, great, it's going to drive better performance because people will know the high performers, the person who's flogging themselves is getting paid more than the person who's just doing a mediocre job. So encourage you to look at it as a positive, even though there'll be a sort of teething period where it can get pretty uncomfortable if you're making some dodgy decisions about who's getting what out of the remuneration pie.
And look, we've still got quite a few people on. I know it's 12:01, but there was a lot. So Cilla, if you've got a couple of minutes, we might just stay on for people who have time. There's a lot of questions about this fixed term contract extensions. And I think they're all a variation on a theme, which is one of the questions was like, if somebody's done 3 months and then they do another 3 months, that's it, they're maxed out, aren't they? Yeah, that's right. So they're maxed out. Yeah. So what happens if there's a break in between? So what happens if they go traveling for 3 months and then come back? Does it start again?
So there are anti-avoidance provisions as well to sort of avoid these sham contracting arrangements. So that will be considered. So if there is a genuine break, but if it's some sort of dodgy stitch up to avoid it, then because you can make the application to the commission, but the intention is that they're successive contracts. So on paper, it's okay, but in practice, if it's a way to avoid these provisions applying, then the Fair Work Commission will take a pretty dim view of that.
Yeah. So Cilla, let's say somebody's put a question here about a fixed term contract. Let's say somebody comes in to do a project role and then a maternity cover comes up and this person likes to do contracting, because some people do like it. It will only be an issue. Is it only an issue if somebody's unhappy, or is it just simply now illegal? That person decides to do different roles within the same company.
Yeah, look, there are as I said, there's anti-avoidance provisions. So if everybody's happy, then on one view, no one ever finds out, right? So you just get away with it. But on its face, those contracts are actually unlawful, and the risk, and there is civil remedy provisions, so there can be penalties both to the company and those people that are involved in it. So I wouldn't in HR want to run the risk of being involved in that, or as an employment lawyer, to be frank, because everybody might be happy one day and then suddenly they're not happy. And then suddenly you're in the Fair Work Commission with the employee saying, I should be a permanent employee. I didn't want to be a contractor.
And so I'm guessing it's about the legal entity that employs them, because if they go to a different part of the company or they go to maybe a different state, that doesn't change it, does it? It's still a fixed term contract with the same company.
Yeah, well, the employing entity, if the employing entity is different, then it would be. But again, you're sneakily looking at ways to get around the legislation, which is kind of they're trying to encourage employers to say, can we give this person a permanent role? If yes, then let's do it, rather than having these rolling fixed term contracts where the employee has an ongoing expectation of work, and it creates this sort of subclass of vulnerable workers. Now, in terms of those exceptions, one of them was the high income threshold. So if this person's getting paid 300 grand, then these things don't apply. But it's geared towards trying to support these vulnerable employees that don't ever have that security of employment. And it's usually for reasons like headcount that, that probably could be changed.
Yeah, okay. Right, we've still got quite a few more, so I'm just trying to condense them a little bit. There was one quick question I saw. Did the Jetstar use internal or external investigators for the case?
Internal.
Internal, okay, great. I think we've answered that one. Let me just get that out of the way. Right, there's a question, do employers need to tell employees that there's been changes to legislation? Or is it up to the individuals to find out for themselves about all these changes? So whether it be pay secrecy or the contracts.
Yeah. Look, no, there's not a proactive requirement that employers inform anybody of any of this. And so the fixed term contract information statement, for example, needs to be provided with a fixed term contract after June. So not generally in terms of these changes. So we're not really seeing employers pushing out this information. But, as REM time comes up, if it's a sort of end of June situation like many companies do have, then, the normal clauses where you get a pay rise and a paragraph that says, you're directed not to talk to any of your employees about this, that's going to be gone. So whether you're pushing out proactive comms or just assuming that people are becoming aware by osmosis or reading the newspaper or the Fair Work Commission or Ombudsman's websites. But no, you don't need to be proactively saying, hey guys, you can all talk about your REM now and do all this. You're not expected or required to do that.
A couple of quick questions about the pay that have just popped up. Was the high income threshold 300, or did you just say as an example?
No, it's the 162. So I just gave 300 as an hour limit.
Yeah,
so it's the
162. Okay. And then somebody else has asked, does this mean all ex gratia payments can be discussed amongst employees? So they can talk about whatever they want whenever it was paid.
Yeah. So
ex gratia payments is
and so an ex gratia payment isn't their remuneration. So if you have a deed of release with someone and you're getting paid, certain amount of pay, if it's expressed as just 50 grand, for example, it's an ex gratia. It is in a contract, but it's not actually your remuneration. But quite often in deeds, it'll be expressed in certain months' pay. So you can then work out what their REM is by that. And so we are then in deeds of release having to put in riders that this, whilst you're required to keep the circumstances of this deed and the terms of this deed confidential, that does not include details about your remuneration. And so it's just additional words in there. So yeah, because a deed is a contract, as is, a contractual, offer of a bonus.
A really interesting question earlier about the flexible working, and it says regarding refusing the flexible working request, is wanting to work other hours in a different company a legitimate reason to not grant flexible hours? Because I think there's this whole thing going on at the moment about people having multiple jobs. And I think, there's in certain industries, a lot of people are doing 2 or 3 jobs to be able to pay their bills. So that's quite an interesting one, isn't it?
It is. I mean, lots of contracts will have a requirement that you are just working for them, but if people are part-time employees, and they might have multiple. So, I mean, that's not something that talks to someone's carers' responsibilities or those things that enshrine that right. But you'd still probably want to avoid ending up in the commission. You'd still want to have a reasonable basis to say no. So if the person says, I want to stop working for you guys at 3 o'clock so that I can do a 4 to 7 shift at the competitor across the road, then you'd have a reasonable basis to say, well, no, we don't want you to do that because they're a competitor. So, it might be a legitimate operational reason. But, flexibility requests are around, age, carers' responsibilities, domestic violence and the like. So it's not just a blanket right. And so just wanting to have more jobs wouldn't enliven that, but you might still end up in a dispute if someone sort of said, I want to be able to leave early so that I can teach violin after I'm a lawyer all day, then, you wouldn't really have a fair basis to say, well, we're concerned about, how your violin teaching might offend, your diligence to Clayton Utz, for example.
Okay. We've still got questions coming in, Cilla. Are you okay for time?
Yeah.
So does 10 days paid domestic violence leave apply to employees who have faced historic abuse, seeking counselling, etc., to manage, say, PTSD relating to domestic violence, or is it limited to current DV situations? That's a very interesting question.
It's a great question. And look, the public policy answer is yes, you should, because they're not that in all of these things, whether it's domestic violence, whether it's sexual harassment, the landscape has shifted significantly sort of post Weinstein scandal in 2017, post Me Too. So the expectation, and this is again off the back of the Respect at Work report, is that you take a trauma-informed and victim-centric approach to it. So the domestic violence leave is being taken in relation to domestic violence that has occurred, albeit several years earlier, and so you would be allowing that employee to take that leave. And then there's questions about, well, do we need evidence of that? And you can do that in a sort of softly way in terms of what supports can we give you? Do we want to offer EAP? But just to understand the historic nature of it. But no, I wouldn't be declining that. It is a legitimate leave that's required to deal with a diagnosis of PTSD that is a consequence of trauma from a domestic violence situation.
Okay. There's still lots of questions, but there was a couple around, no, that was more salary. I think we got that. Where was it? About the roping in. Can roping in still happen if the employer has struck an agreement specifically to avoid being roped in?
No, if you've got an agreement, your own agreement, you won't be roped in, which is why everybody's rushing out to get their own agreements. So you won't be roped in, and you can't be approached to have to be a common interest employer with another. So it's really, these legislative changes have really produced the outcome that employers just going out and making their own. So, then they've got control of their own destiny. So no, the short answer is no.
Yeah. And then, okay, let me do one more. I had a couple written down, but I think we'll just have to pick one. There was one that we haven't sort of covered, and it's now missing. Hang on. Does an open tender process for a government contract qualify as no reasonable prospect of renewal? I guess I think this is to do with the fixed term contracts, is it?
Does
an open tender process for a government contract qualify as no reasonable prospect of renewal? I don't know if that relates to the contracts that we're talking about or something else.
There's an exception to fixed term contract. So it's open so that there wouldn't be an end date in that scenario, or if there's no, I'm just trying to.
Yeah, I don't know. I can't. Yeah, it was at 21 past. I can't remember what we're talking about at that point. All right, one more. We'll do one more.
Sorry.
Here you go.
No, I was just going to say, if it's a government funded contract, then generally you might fit within the government funded exceptions to it. But if it was open ended, then it wouldn't be fixed term, so it wouldn't be sort of captured by those provisions in the first instance, if I'm understanding the question correctly.
Yeah, I think so. Yeah, because they were coming through at different times. I needed to check which part it related to. Oh, last one. There's still more about this pay stuff, Cilla. So do increases reflected and converted as annual leave, i.e. a salary increase chosen as leave, count towards the high income threshold?
Sorry, say that again.
Do increases reflected and converted as annual? So I guess if somebody buys
if someone's getting extra annual leave in lieu of, I mean, that's annual leave rather than their remuneration, but it's remuneration and things that contribute or can sort of can determine remuneration. So I guess if the contract said you're on 160K and you've got 5 weeks annual leave, then it's their leave, albeit a contractual entitlement. The legislation and the explanatory memorandum don't go into that level of detail, so it's probably going to be one that we start understanding once there's some cases. But that's a really interesting one, because I think that question talks to probably what the clever answer might be, which is, can we come up with creative non-remuneration based entitlements? But it's talking about their pay, their employment terms and conditions that need to be used to work out their pay. So it really is talking about money rather than other benefits. So I think the short answer is no, but it would be interesting to see where the legislation would land if it was tested. There's obviously not any cases yet.
Thank you so much, Cilla. Wow, 12:15. We could keep going, but we better leave it there. But yeah, thank you again so much for a wonderful session. And everybody, they've gone now, but everybody's been leaving very kind comments. So thank you so much for that. But for everybody left over, there's still quite a few of you. I will send out the slides hopefully this afternoon. Cilla will coordinate that. Cilla and I will coordinate.
Nice.
Yeah, and then we'll thank you. Yeah. And then I will get the recording out hopefully next week. Bit of a delay with the Easter break, but keep an eye on our website and LinkedIn. Our next event is already been planned. It's hopefully sort of late June, and it's going to be on diversity of thought and dyslexia at work. So yeah, keep an eye out for that and enjoy the rest of your day wherever you are. Thank you, Cilla.
Thanks, everybody. Thanks, Angela.
Cheers. Bye. Bye.